They're good.
All right, good afternoon. My name is Sharma. I'm the president of the Federalist Society here at Moritz. And on behalf of all Federalist Societies nationally, I want to welcome you to our event. And I'd like to take just since this is our first meeting, just a little short time to introduce what is the Federalist Society, who are we, and why you should continue to come to our events. The Federalist Society is an organization of mostly libertarian and conservative law students and legal scholars, although we are open to absolutely everyone. We seek to educate, recruit, and mobilize professionals in the legal field for the cause of liberty and the rule of law. When you join the Federalist Society, you're in good company. We have over 20,000 members nationally, and we have chapters in virtually every city in the country and at virtually every law school in the country. Our chapter here at Moritz will be hosting a variety of speeches, debates, and panel discussions throughout the year with the country's top legal scholars, of course. The topics will range from anything in intellectual property to environmental litigation to class action tort suits to natural rights and, of course, today, constitutional law. Regardless of your plan specification or regardless of what you plan to do with your law degree, we hope that you will join us for our events because we've got something for everyone. I'm pleased to be working with a very terrific board this year, and I'd like to take a minute to just introduce them. Our Vice President, Brian Stewart, our Secretary, Jillian, and our Treasurer, Thad, who is currently AWOL, and our YouTube czar is Tom, so he's helping us out with that. We do have a YouTube channel, as the recording shows, and as you probably noticed, it's at Ohio State Federalist. So just type that in. This is our first recording. We hope to have this up very soon. And I'd like to take just a moment to introduce to you our speaker for today, Professor Kurt Lash of the University of Illinois Law School. Professor Lash received his bachelor's degree from Whitman College before earning a JD at Yale Law School. After graduating from Yale, he clerked for the Honorable Robert Beezer of the U.S. Court of Appeals for the 9th Circuit. Professor Lash was a former member of Loyola Law School's faculty, and he published numerous articles in constitutional law and theory. His work has appeared in some of the top law journals of the country, including Stanford Law Review, Virginia Law Review, Georgetown Law Journal, Northwestern Law Review, and Texas Law Review. 2009, Oxford University Press published his book, which is called The Lost History of the 9th Amendment. We're very pleased to have Professor Lash with us today. He will be speaking on the topic of the 9th and 10th Amendments and the relationship between the federal and state governments. Please join me in welcoming Professor Lash.
Thanks to the Federalist Society for bringing me out. You know, you mentioned, it has been a special privilege to publish my work in a number of law reviews, but you didn't mention the most important one. I have a great piece on religious liberty in the Ohio State journal, so that's add that to the list as well. Thanks so much for coming out. It's a pleasure to see you guys. Good to see you here. Then when you come out and crush us when Ohio State plays Illinois here in the coming football season. Yeah, I know. That's okay. I'm going to talk today, and I guess it's kind of kicking off the season of speakers that you're going to be having, talking about constitutional principles and limited constitutional government. And of all things, I'm going to be talking to you about the 9th Amendment, something which may have gotten, what, a blip in terms of your constitutional law classes. But it's been one of the focuses of my research in terms of looking back at early history surrounding the adoption of the Bill of Rights. And as I was researching that history, I came upon a great deal of evidence that suggested the 9th Amendment, particularly in its relationship with the 10th Amendment, was originally understood in a very different manner than how courts and scholars generally look at the 9th and 10th Amendments today. So what I'm going to do today is talk about that early understanding of the 9th and 10th Amendments, talk a little bit about its implications for current construction of federal power, and I'll do that for about 20 minutes, and then we'll just open it up, and we can have a conversation about the materials that I've talked about. All right. So, Oxford, available at all fine bookstores, okay. Oxford University Press just last year published the book, and a lot of what I'm going to talk about today is going to be summarizing a lot of this evidence. So, without any further ado, I'll present the early lost history of the 9th Amendment, which requires us to begin at the beginning, which is the 10th Amendment. To understand the 9th, you've got to know the 10th. Generally understood as a states' rights provision in the Bill of Rights, talks about how power is not delegated nor denied to the states or reserved to the states, respectively, or the people. You might have talked a little bit about it in constitutional law. It didn't get a lot of jurisprudential activity during most of the 20th century, but once you get to the Rehnquist Court, the 10th Amendment had a little bit of a renaissance in terms of its use by majorities under the Rehnquist Court, particularly in cases like Lopez, New York, and Prince, and Morrison. The court began to talk about how the 10th Amendment called for limited construction of federal power in order to preserve, wherever possible, a certain degree of autonomy to the states. So the 10th Amendment is used as a federalism kind of provision, preserving local autonomy. And you probably developed a little bit of that in your courses. The 9th Amendment, to the extent that it was discussed at all, probably was discussed in a very different way, and as pointing in a very different direction. It talks about the enumeration of certain rights. The Constitution shall not be construed to deny or disparage others retained by the people. You might have talked about possible meanings of the 9th Amendment in Griswold against Connecticut. Griswold, 1960s case where the court strikes down a Connecticut anti-contraceptive law. And in doing so, on the basis of due process liberty, some members of the court, a little bit in the lead opinion, but particularly in Justice Goldberg's opinion, he talks about how, well, yeah, privacy isn't listed in the Constitution, but there's the 9th Amendment. The 9th Amendment talks about other rights retained by the people, besides those strictly enumerated. And even though the court has never talked about the 9th Amendment before, and even though there's no history in terms of the application of the 9th Amendment, nevertheless, it's part of the Constitution, Goldberg wrote, and therefore it deserves to be enforced every bit as much as other provisions in the Bill of Rights. And he believed it was perfectly appropriate to use it in that case, to use it as partial justification for striking down a state law banning the distribution of contraceptives. So, and then that, of course, develops. You get 9th Amendment discussions in a number of due process liberty cases, substantive due process, right to privacy, this idea of the 9th Amendment and unenumerated rights, very commonly talked about in the literature as supporting the court's individual rights of jurisprudence under the right to privacy. So when you compare these two lines of cases, it appears as if the 9th and 10th Amendments are in conflict. Right? 10th Amendment is states' rights, uphold state laws, uphold state autonomy. 9th Amendment, individual rights, personal freedoms, strike down state laws that interfere with personal freedoms. So they battle it out on a case-by-case basis, right? You know, the individual freedom against states' rights. Sometimes one wins, sometimes the other wins, but invariably they're in tension with one another. That's the jurisprudence that you have today with the 9th and 10th Amendments. But as I looked back into the history and the original understanding, something very different emerged. In the beginning, the understanding of the 9th and 10th Amendments was that they weren't in conflict. They actually worked together. And together created a rule of narrow construction of federal power in order to preserve, wherever possible, local autonomy, or the people's retained right to local self-government. How this original idea arose and why we lost it forms a lot of the basis of my work. And again, I'm going to kind of summarize this for the next 10 or 15 minutes or so. But it requires going back into history. Okay, so let's review, class, shall we? The original Constitution did not have a Bill of Rights. As proposed by the gentlemen in Philadelphia, and they sent it out to the states, it has all its structural provisions, Article 1, 2, 3, etc., but there's no Bill of Rights there. And that, of course, was rather controversial, but there was a reason why the original Constitution didn't have a Bill of Rights. According to the Federalists who framed it, and who are now advocating its adoption, listen, we're creating something here on a federal level that's very different than what you have on a state level. Yes, states have their own Bill of Rights or declarations of rights, but they need them because it's presumed that state governments have general police powers, meaning they can enact anything they want to enact for the health, welfare, or moral good of the citizenry.